All right, Ted, we're live.
Hey, I like that.
Yeah, welcome everybody. My name is Mike Menninger. I'm here with Ted Gudorf. We are the estate planning attorneys at Gudorf Law Group. We're really grateful for everybody who's willing to attend and spend a little bit of your morning with us. We've got a really impactful presentation for you. And I want to take a few minutes to kind of introduce you to where we are and what we're doing. And then I'll bring Ted on and he'll kind of take you through the meat of everything. And I'll be back here to reconvene in a little bit. So as we get through this, let me make sure that everybody can see the PowerPoint. We'll get it up and rocking here. And here you go, planning essentials amidst the COVID-19 pandemic. That's really going to be the focus of what we're talking about here today. So as we get started, I want to let you know that you do have a way to interact with us. You can certainly ask questions to us by clicking the Q&A button you see there. You can raise your hand and I'll be able to address you and figure out if there's any issues or anything going on. Certainly, we can chat through any problems that you might be having by using that chat feature that you see there. If anybody is having a hard time hearing us or seeing us, if you can see those options there, please let me know. We'll try to work through it. We haven't really seen too many problems, but we know those things can happen. If something were to happen and we get disconnected, or if you get disconnected, just use the same link that you did before. And that's what we would do. And we'll hopefully end up right back here in the same room talking. So I've got a quick, make sure everyone's kind of there and participating. I've got a quick anonymous poll, but I would like to maybe get a little bit of feedback from everybody. So we're going to take 30 seconds to launch this poll and hopefully get a little bit of data. Ted, I don't know about you, but this social distancing thing, I mean, I don't know that I've certainly never experienced anything like this in my life. And, you know, it's just been strange to be physically disconnected, but I'll tell you that, and I know you've done the same thing, but we've had some great experiences in family Zoom meetings and happy hours and family dinners. So stay apart together, I think, is one of the hashtags that I've seen. How has your social distancing experience been?
Well, the thing that stands out for me the most, I will tell you, probably like a lot of people, I've gained about 5 pounds in the last 6 weeks. So I've probably have had more dinners with my lovely bride in the last 6 weeks than in the last 2 years. So yeah, we're we are cooking up a storm at home, and I'm eating a lot. So I have to find a way to get some exercise in here. That's number one thing I've observed. Secondarily,
Yeah.
I heard from my wife yesterday that I need a haircut, and I haven't figured that out yet. So yeah, sometime in here, I've got to get the clippers out, and maybe, and she's indicated she's not going to cut my hair for me. So I may have to take things into my own hands here, which may be pretty dangerous.
We just gave the 9-year-old the old clipper treatment. He survived it. I'm sure you'll be okay. Well, so the results are in, Ted. As you expect, the vast majority of people here, the first thing they're going to do is hug their kids and their grandkids. And I think that is a really perfect and appropriate response. By the way, stick with us through the end here, because when we get to the end, we got some things that we're going to give you and some opportunities for you to interact with us and kind of get some bonus items. So again, we're really appreciative of people willing to spend some time. So what are we going to cover here today? Well, many of you might be kind of familiar with what estate planning is, but we're going to kind of go over what our definition of estate planning is and what it really means to us. We're going to spend some time talking about emergency planning for a hospitalization and some of the things that you can do and some tips that might help you should something happen and we have little time to react. Ted's going to spend some time talking through the key documents that everybody needs if there's a crisis, whether it be COVID-19 or something else. We're going to talk about probate court and then how to get started if you kind of want to get back into your planning process. So I think a lot of folks out there know who we are, but I wanted to spend just a few moments reintroducing you to us. You can see the picture of our wonderful team there. We've been doing this since 1992. We focus exclusively on estate planning, elder law, and estate administration as a law firm. That's all that we do. The firm was built on the foundation and the principles of making sure that our clients and their families are protected for the most important things in their life, and certainly during some of the more difficult times in their life. We're AV rated, which is a designation that's special for us because it is a designation reserved for only the top 5% of law firms in both skill and ethic. And it takes both of those things to do what we do for the benefit of our clients and their families. So we like to talk about what integrated planning is. And integrated planning, it's comprehensive planning. I think a lot of people think of estate planning and they think of wills and powers of attorney and trusts, and they're right about those things. But integrated planning goes beyond just those documents. It does tax planning. It does retirement planning, long-term care planning, and certainly asset protection planning for the things that you've accumulated that you intend to pass on and leave a legacy behind. So for you and your family. How do we do integrated planning here? Well, you can see that we've got our flagship firm, Gudorf Law Group. That's where we do the estate planning and elder law and the estate administration. We've also got our insurance agency, our financial services firm, and also our tax firm. A lot of our clients like having all four of these in one place. Some of our clients have existing relationships. Either way, we want to make sure that our clients are covered in anything that they need. And while some of our clients use all four, some of our clients only use one company, but we're here to make sure that we've got every piece to take care of our people. Oh, so where are we? I think a lot of you know that our main office is here in the Clayton area. We also have an office up north in Troy, and we also have one down south in Centerville to make sure that we're able to service our clients all over the greater Dayton region. But we do have some new locations. I say this a little bit tongue-in-cheek, but it's real. We've got, given everything that's happening, we've really expanded our use of virtual meetings and video technology to keep our people safe, to keep our clients and their people safe. So we have the ability to meet with people remotely. And in fact, we're doing it quite often these days, and frankly, we're finding it almost to be just as easy as meeting in person. So for anybody who wants to meet us in person, great. But for a lot of the people who aren't ready for that, or you know, things aren't quite back to normal yet, we do have the ability to meet virtually. So Ted, I see a couple questions coming in. I think I'm going to hand the reins over to you here, and I want you to kind of take people into what the heck it means to do estate and elder law planning. So feel free to jump on in here, Ted.
Thanks, Mike. So let's talk about how do we define estate and elder law planning. This is a definition that I've used for a long time. I say estate and elder law planning is a lifetime process whereby I control and protect my property while I'm alive and well. I take care of myself and my loved ones if I become mentally disabled. I give what I want to whom I want, when I want, and the way I want. And I do so with the lowest amount of professional fees and court costs possible. Now, there are a couple of things here that I want to emphasize about this definition. Real things I want to highlight. Probably the most important thing that I've discovered over my 30 plus years of doing estate planning is it is important to understand that this is truly a lifetime process. Unfortunately, so many people, when they begin this, they think about this as more of a one and done. You know, our law firm has really learned that planning is a process, not an event. Yeah, I understand that most of you would like to go see a lawyer how many times? Well, the reality is that if we're really honest with each other, we understand that you really don't want to come and see us at all. But hey, let me simply illustrate it this way. Let's say you're 30 years old and you have a couple children and you decide to go do your will or your trust to protect your kids. You take that, you get it done, you sign it, and you put it in your safe deposit box. Then some 50 years, 55 years later, let's say you're 85 years old and you pass away. Well, that plan that you did when you were 30 is going to work perfectly well, right? Well, of course not. And we understand that. Why is that not going to work? Well, it is because things do what? Things change. All kinds of things change that affect our estate plans. Um, our health changes, the law changes, our family changes, divorces happen, deaths happen, disabilities happen. Hopefully our estate grows. The things we own change. So the bottom line is that this change is what occurs in our lifetime. And therefore, it is important to work with an estate planning law firm that will allow your plan to change as your estate changes. That is a really important part. And later, I'm going to talk to you about our Legacy Club, because it's our Legacy Club that ensures that our clients' plans work when they need it to work. The second thing I want to talk a little bit about here with the definition is to talk about, I take care of myself and my loved ones if I become mentally disabled. Yeah, the mental disability planning, I've learned that that is really what is lacking in the bulk of estate plans that I see out here. To the extent that we have people who have done any planning, they don't deal well with this issue. I have made it a integral part of our integrated estate planning to make sure that we discuss with you how you want to be cared for in the event of a mental disability, making sure that we have the legal documents in place if that occurs, but more importantly, that we have a plan to pay for your care. So mental disability planning is a part of what we're going to talk about in a little bit. But I want to tell you this, before we get there, I want to discuss with you what we do in the face of an emergency hospitalization. Let's talk about the current situation we're facing with COVID-19, and let's see if we can. Well, let me go back here. See if it'll let me. I apologize for that. I'm having a little hard time getting a hold of this here. There we go. So let's talk about emergency planning for a hospitalization. A couple things that we have to think about. When we go to the hospital with COVID-19, because we feel like we've been infected with the virus, we got to realize that we may be forced to go there alone. And if we're going to go there alone, then we may want to take certain steps, and we're going to talk about what those steps are. We also have to realize that we may not go to a preferred hospital. You may have a hospital that you think you would like to go to, and it turns out you end up being somewhere else. Also, your baseline information is going to have to be shared. So what we're going to recommend that you do today is that you prepare what we're calling a grab and go kit. And we have that ready to go in advance. We need to talk a little bit about what that looks like. There we go. In our grab and go kit, what we're recommending is that we have a cover page. And on that cover page in the grab and go kit, it should include your name, your address, your phone number, the date of birth, any allergies you have. It should include any emergency contact. What is their name? What's their phone number? What's their email? And in particular, what's their text information? And then we want to give our healthcare professionals information about you. So what can that be? Well, how about a short note with some specifics? Any medical conditions, your medications, do you have any implants? How do you walk? Special precautions for positioning you? Or do you have any hearing issues or eyesight issues? Or are you experiencing any cognitive abilities? It is really important that you write a short note with any specifics, because we will want your healthcare professionals to know those. And remember, if you're by yourself, having this prepared on a note in your kit will go a long way to helping out our healthcare professionals. Other items to include in our grab and go kit. How about a list of dosages for prescribed medications or over-the-counter medications? A list of past surgeries or hospitalizations would be helpful. And for sure, having a copy of all of our insurance cards. And then we're going to talk about the legal documents, the HIPAA authorization, the healthcare power of attorney, the living will. And then we're going to also suggest an iPad or tablet for communication. I'm sure all of you have seen how the iPhone or the iPads have enabled COVID patients to communicate with their family. We're gonna cover some of the legal documents next. So let's talk about the key estate planning documents that everybody should have. You're going to see a list here of 6. Tonight, what we're talking about, or today, what we're talking about are the basic documents. And we're not going to talk about any advanced documents in depth. So let's talk about these basic 6 documents: the living will, the healthcare power of attorney, the HIPAA authorization, the personal representative for the disposition of remains, your general power of attorney, and then your trust or your pour over will. I'm going to focus on the first 3 today. So let's talk a little bit about each one of them. It is important to understand that nearly 89% of Americans think that doctors should discuss end-of-life care with their patients. But what's the reality? Yeah, the reality is that only 17% say they've had those conversations. So there is a big gap between what we think we should do and what has actually occurred. As I indicated in prior seminars that I've done, 70% of adult Americans have failed to plan as it pertains to a living will. Look at this. 71% of adult Americans do not even have a living will. So that tells us the lack of planning that has occurred. When we talk about Ohio advanced directives, what are the requirements? Well, the first thing is that you have to be over 18, but boy, once you hit 18, you should have some advanced directives. So for those of you who have family members, think about the younger generation. They should all have these documents, in particular, a healthcare power of attorney and a living will. If you wait too long and something happens, you may no longer be able to execute it. Without proper advanced directives, you may end up with a guardianship. And a guardianship is living probate. That really becomes the only option, is to have the probate court step in and appoint a guardian, whereas the living will and the healthcare power of attorney can help us avoid the guardianship process, the entire probate process. When we talk about a competent adult, what is competency? Well, when dealing with the elderly and mentally challenged, this can at times be our biggest issue. The legal standard is not the same as the medical standard. An individual's best interest should always be protected. The things that we have to think about relative to competency is the variability of our client's state of mind, the ability to appreciate the consequences of a decision, the fairness of that decision, and then the consistency of that decision with the prior planning documents. You know, at the end of the day, we always ask people, you know, do you know who you are? Do you know the natural objects of your bounty? That is, do you know who your family are? And then do you have an appreciation for what you own? When it comes to executing wills and trusts, that is the basic standard. There's no doubt that competency is at the foundation of being able to be competent in order to execute documents. So let's talk about a living will. What is a living will? You say you want to you say what you want to happen with respect to extraordinary measures being used to keep you alive. But here's what's really important. Only in the event that you are in a terminal or permanently unconscious state. I think far too many people think that a living will is like a DNR order and takes effect when they're not terminal or not permanently unconscious. So it's really important to get this. Two physicians are going to have to determine that you're either terminal, as defined under the law, which basically means that death is imminent, or that you are already permanently unconscious. Now, if that circumstance does occur, then the physician is authorized to withdraw extraordinary measures that are being used to keep you alive. It will allow you to die naturally, and it will instruct all your healthcare professionals to take no action to postpone your death, but to allow you to die naturally. Pain management is required to be maintained throughout this process. It is important to understand that. We want to ensure it is consistent with all your healthcare documents. You may also designate your wishes about organ and tissue donation within the confines of the living will. Now, I talked briefly about the DNR order. Remember, the DNR is only limited to your wishes regarding your desire for CPR if you have cardiac arrest or respiratory arrest. The living will asks the doctor to issue an order for a DNR. Well, the reality is it is important when we're dealing with COVID-19 that if for some reason you have already gotten a DNR order in place. Now that DNR order is not the same as a living will. A DNR order is a request that you make through your physician to have a notation placed in your chart that says you do not want to be resuscitated. You do not want CPR. You do not want intubation. You do not want a ventilator. That's what the DNR order is going to say. The DNR order can take effect before you are terminal or permanently unconscious. Okay, so that's the difference between the two. So if you had a DNR order issued and you come down with COVID-19, you're not going to be permanently unconscious, you're not going to be terminal, but because you've had a DNR order, it could prevent you from getting CPR or getting intubation or getting a ventilator. So what we have done is have explained this to people so that we can give greater instructions. Presumably, most of us, not all of us, but many of us, if found to have the virus, would like to have CPR. But maybe in other circumstances, we do not want CPR. But as it pertains to the virus, we do. So what do? Well, we have the ability to list specific instructions. And we're going to want to put those instructions, in my opinion, in both your healthcare power of attorney as well as in your living will, which specifically states, look, if I contract the virus, I do want to have these extraordinary measures utilized to keep me alive. Well, what is CPR? Well, remember, it includes chest compressions, the insertion of an artificial airway, the administration of a resuscitation drug, defibrillation of the heart, respiratory assistance, or resuscitative intravenous line being utilized. That's what we're talking about. Do you want CPR to be able to be utilized? Many people don't if they're permanently unconscious or terminal, but before that, they do. What is permanently unconscious? It's an irreversible condition in which the patient is permanently unaware of their surroundings. Two doctors must agree that there is no higher brain function and that you're unable to suffer or feel pain. Now, this healthcare power of attorney, how does it fit with respect to the living will, the DNR order, and the HIPAA authorization? Remember, a HIPAA authorization, which we have all of our clients sign, authorizes individuals that you designate to be able to get medical information about you, including being able to have conversations with your doctors. Secondarily, the DNR order that we talked about is a request that you sign for your doctor to place in your chart the fact that you do not want CPR, that you do not want extraordinary measures used to keep you alive. Thirdly, your living will states what you want to have happen in the event that you become permanently unconscious or terminal. Whereas a healthcare power of attorney is the appointment of an agent to make healthcare decisions for you if you're deemed to be incompetent, whether that's temporarily or permanently incompetent. You are designating someone else. The point is, as long as you are competent, you will be able to make medical decisions for yourself. Having said that, if you are no longer competent, then your agent will make all medical decisions for you. Yeah, it includes what kind of treatment, what hospital you go to, what physicians treat you. It even includes designating what nursing home you'll go to. So designating someone to make medical decisions for you is extremely important. Now, if you want to give your agent the ability to withdraw life-sustaining treatment, you can do so. There's a box on the form that you can check that allows them to authorize that. Under no circumstances will they be able to withdraw comfort care. Now, if you have previously given consent, there will be no withdrawal unless the condition has worsened or treatment is no longer a benefit. Also, if the patient is pregnant, they cannot withdraw if the fetus would be affected unless two doctors say the fetus will not be born alive. Now, what is a terminal condition? A terminal condition is an irreversible, incurable, and untreatable condition caused by disease, illness, or injury from which, to a reasonable degree of medical certainty, as determined by two doctors, you will not recover. Basically, it means what we call brain dead. There's no higher brain function. It's irreversible. It's incurable. It's untreatable. The physicians who examine you must determine there is no chance of recovery and death is likely to occur within a relatively short time if life-sustaining treatment is not administered. I've already discussed the HIPAA authorizations, so I'm going to pass through that. So when we talk about, when we move away from the medical decisions and we get more into the estate planning area, we always recommend that our clients have a general or a financial durable power of attorney. Now, in our office, unlike most law firms, in our office, these general powers of attorney are probably less important because most of our clients have trusts, and the trusts own the assets, and when the trusts own it, the trustees have control without having to have a power of attorney. But if you don't have a trust, and many law firms only do wills that end up in probate, and under those circumstances, the general power of attorney becomes more important because you don't have a trust. So what is this power of attorney? You appoint someone to make decisions with regard to your finances and other personal affairs for you during a period of temporary or permanent incapacity. Usually, incapacity is a condition of the power of attorney, but not always. It could also go into effect immediately. The difference is between whether it's an immediate power of attorney or a springing power of attorney that only takes effect. Irregardless whether it is immediate or whether it is springing, the idea is for that agent to be able to make decisions even if you become mentally incompetent. The agent can either act alone or can act jointly with another agent or act independent of another agent. There are a few circumstances where we have set forth in the power of attorney that the agents can act independent of each other. So at the end of the day, it depends upon the family situation as to exactly the terms of the power of attorney. This other thing that oftentimes we want to deal with along with a power of attorney is make sure that we appoint a personal representative to handle your funeral and burial arrangement. This gives us the ability to have clearer directions and greater protections if there are any family disputes over whether it be funeral plans or disposition decisions. So Ohio law allows an individual to appoint that representative. And we do this in all of our estate plans. We make sure that it's very clear we know who is going to be in charge of handling those funeral and burial. We think that's important. So many of us are familiar with a will. We understand that a will is a formal document that is useless until death and only transfers property you own in your sole name at death. Most of us understand that a will does not operate on jointly owned property or property that has a beneficiary designation like life insurance or an annuity or a retirement account. What a lot of people fail to understand is the significance of the fact that a will guarantees probate. What is probate? It is a court proceeding whereby we publish a notice in the newspaper and give notice to your creditors. Everything is public information. The court is able to put your will and the inventory of everything you own out on the internet for everybody to go see. Why do we not like probate? Well, in large part because one, it's public. Two, we oftentimes have a 2-year delay in wrapping up an estate. Yeah, 2 years. And three, the cost. The cost of probate is roughly 5% of the value of your estate. So if you have a $500,000 estate, and an estate is everything that you own, take 5%, it's a $25,000 lawyer fee. Now the reality is that many of our clients want to avoid probate. But if it's important to understand, if your estate relies upon your will, a will will guarantee probate. So what is the alternative? Well, we think that it is a trust-based plan. So what is a trust? We don't want to make this overly complicated. I always say that a trust is a bucket. Yeah, and it's a bucket where we take what you own and we put what you own in the bucket. It might be your checking, your savings, your CDs, your house, your boat, your farm, whatever it is that you own. With one exception, we're going to put it in the bucket. Putting it in the bucket is the key to an effective estate plan. Now, this bucket has a more formal legal definition. I'm going to go over this with you, but I still think it's better to think of it as a bucket. So a trust is a legal entity apart from the person or persons who create it. It is designed to hold and control the distribution of property. When we have a trust, we have to think of 3 separate roles. First of all, the trust maker, that's the person, that's you who create and funds the trust. Number 2, the trustee who holds the property and administers the trust, and then 3, the beneficiary who receives the benefit from the trust. So if we have a simple revocable trust, typically you're going to be all 3. You're going to be the trust maker, the trustee, and the beneficiary. And if you're a married couple, oftentimes you'll do what we call a joint trust, where both of you are the trust makers, the trustees, and the beneficiaries during your lifetime. So on the one hand, the short version, it's simply a bucket. This is the more technical or the more legal definition. So how does this revocable living trust differ from a will? You see, a revocable trust is a private document. It doesn't go to probate court. It doesn't go to the county recorder's office. It's never subject to becoming a public record. Therefore, assets owned by this revocable trust avoid both living probate and death probate. Also, it is important to know that assets of the trust upon your passing are distributed without that notice being published in the newspaper or mailed to creditors. In other words, if we have a trust, we're not going to probate your will as long as the trust owns what you own. Trust administration is far more efficient, has far fewer fees. As I said earlier, oftentimes we can eliminate 90% of that probate fee when somebody passes if we have a trust. So it is important to know that you can have a trust, but understand it, what I say, it is not a magic book. You can have a trust and still end up in probate. Just having a trust is insufficient if your assets are not aligned. And this is what so many people make a mistake. They'll go to a lawyer, they'll create a trust, and then they won't ever put anything in the bucket. We spend an enormous amount of time making sure that our clients understand that you have to align your assets with the bucket. Asset alignment is the process of retitling your assets into your trust and updating your beneficiary designations to be consistent with your overall plan. So even if you have a trust, you can have probate if your assets are not properly aligned. That's correct. So without proper asset alignment, you may not be able to take advantage of all of the tax exemptions and other asset protection benefits that are available through a trust, because they'll still have to go through the probate process if they're not properly aligned. Well, as I indicated, what kind of property can we put into a trust? It includes your home, your farm, your stock, your bonds. It's just about everything you own. There is one thing you cannot put into a trust, and that is your retirement account. Your IRA or your 401k or your 403b have to have a beneficiary designation on them, but they cannot be owned during your lifetime by your trust. So oftentimes we're going to make sure that we have properly designated the beneficiaries on the retirement accounts, while everything else is going to be owned by the revocable trust that you have.
Well, Ted, we're going to be getting into kind of what our process is and what things look like. I wanted to jump back in for a second. You know, again, this is anonymous. I'm going to go ahead and launch this poll here. If you wouldn't mind taking a minute and giving us a little feedback on this. You know, I like to say this, and you and I have talked about this, the documents get easy. They can be easy, but the real challenge is having the courage and being willing to invest the appropriate amount of time and effort into having the conversations. We know it, we facilitate these conversations, but we see it all the time where sometimes this stuff is just really hard to think about. What's going to happen with our assets, or even kind of where we are today, what's going to happen with ourselves if we end up catching the virus, or what do we do in these emergency situations. I can tell you that if you've got the courage to have these conversations with your planners, with your families, with your doctors, so many of these things, they fall into place so much easier. Yeah, it's the conversation is where all this stuff starts. So looks like our results are in here. You know, Ted, it's not going to be shocking to you that the statistics in our poll demonstrate exactly what our slide said earlier. Over 70% of people have not talked to their family or their doctors about their end-of-life treatment issues. And a vast majority of people, in fact, we only had one person who said they were confident that their advanced directives are going to do what they're supposed to do. So that's kind of what we thought, and we appreciate everybody's feedback. We don't make this stuff up. It is absolutely reflective of what we see out there in the market. So Ted, I'm going to give you control back here and kind of let you walk everybody through our process and who we are and how we do things a little differently.
What makes us different? Well, a long time ago, we developed a 7-step process to take our prospective clients through to make sure that they got a plan in place. I want to walk you through this 7 steps because this is how we are really different. You know, the first step is for you to fill out a client organizer. That client organizer is really important, but it is the first step. Please understand that it's 100% confidential. It's only 4 pages, but it gives us a starting point to analyze your current situation. It's going to list your name and your address and your kids' names and their addresses, and then a general description about what it is you own broken down by category, and then who your other advisors are. And it's going to talk a little bit about your current income level so we can get a general idea so we can have a meaningful conversation about your goals. Look, we're planners. We thrive upon having information, and we ask you to get this to us a couple days ahead of time because we're going to do our homework. Whether you meet with Mike or I, we will look at your client organizer before we meet. You filling out the organizer ahead of time and getting it to us will save us a good hour of time having to do fact finding. Bottom line is that organizer is necessary for us to give you good advice. Once you get that organizer completed, though, the next step in the process is to meet with Mike or I. As a part of attending this workshop, we are going to offer you a no cost, no obligation conversation with either Mike or I. We're very willing to do this virtually. We can do Zoom or go to meetings or whatever you prefer to start this conversation. With appropriate social distancing, we can also meet you in one of our offices. We are taking steps here at the office to properly sanitize the offices, the conference rooms where we meet in. What do we want to talk about at the meeting? Well, we want to know what our goals are most important to you, what concerns or issues are preventing you from achieving those goals. We also want to check in with you. Have you made a decision over who you trust with decision making if you're incapacitated? Who are you going to designate on that healthcare power of attorney? Who are you going to put on that HIPAA authorization? Who is going to be your successor trustee after you pass away? Well, after we find out exactly what your goals are, we will give you a fixed price quote. You see, everything we do here at Goodorf Law Group is based upon a fixed flat fee quote. All of our planning is quoted in advance. We're most comfortable with that. I'm going to share with you in a little bit what the costs are. Bottom line is, if you decide you want to work with us, the next step is for us to design your plan. We're going to work with you to tailor it for your specific concerns, to tailor it for your family, depending upon what your goals are. It necessarily will include a discussion of all your assets. We'll talk about tax treatment. ease of transition. We'll talk about asset alignment. All of that is really important in the overall design. After we design your plan, then we'll go build that plan. And then when we build that plan, we'll provide you with an easy to read diagram, which you can take a look at. We'll review your legal documents. We'll answer any questions you have. We'll then sign those documents, notarize those documents, and place those in binders for you. After we have signed the documents, the asset alignment process has to occur. And it really involves step 5 and 6. In step 5, we're going to coordinate with your current existing, might be CPA, it might be your family attorney, it might be your financial advisor, your insurance agent. One thing we've learned is it is important to make sure that we have all your advisors on the same page. And we will serve as your quarterback. We will make that happen. In addition to that, we are going to host a monthly workshop for us to be able to teach you how to align your assets with your plan and how to best utilize the tools we provide in all of our estate plans. That funding workshop or that asset alignment workshop is really at the core of making sure we get all of that, all of those assets transferred into the trust. Bottom line is we're going to work with you. We'll work with your financial firms, your banks, your insurance agents to make sure that everything is titled correctly. Now, the last part of what we do is extremely important. I want to introduce you to a concept that deals with what to do when there are changes. Whether there are changes with respect to your health or the law or anything else, we want you to be able to take advantage of our counseling on what to do in the event there are changes. So what we have created is the Legacy Club. The Legacy Club features a family meeting for you, and maybe it's just those you're going to put in charge, the decision makers, or maybe it's the whole family. But we're going to be able to host a family meeting to explain your plan to those loved ones that you have. In addition, as a part of the Legacy Club, we're going to continue our educational workshops. They happen on a regular basis. We have an annual estate planning and tax law review workshop. We oftentimes have other workshops dealing with current topics. I'm currently working on one to help business owners, farmers, realtors, plumbers, how to minimize self-employment taxes by creating an S corporation for their business. That just kind of gives you an idea of some of the workshops that we periodically will host. In addition to those kind of workshops, if you're a member of the Legacy Club, the changes to the plan, including maybe changing your beneficiaries or changing those who are in charge, are included and are able to be made at no additional charge. Perhaps we will provide ongoing assistance with asset alignment. You may buy a new car or a new piece of real estate and need help understanding how to properly fund it. It may just mean you need to meet with us because some family member is having a difficult time or has passed away or a daughter has been divorced. The bottom line is that our Legacy Club members are able to come see us and receive that ongoing counseling and communication about your estate plan. Lastly, we do have some fun client events that we host that our Legacy Club members participate in. Sometimes it's our Oktoberfest, sometimes it's a wine tasting, sometimes it's an open house, but it's an opportunity for us to see and meet and greet and talk to our clients on a more informal basis. So that's our Legacy Club, and it's probably the single biggest addition that we've added to the firm over the last 5 years.
Hey, Ted, before we get into, how to get started here, one question. What if I have POD on my accounts? Do I need a trust?
Well, this is a real problem that we have. I am not a fan of POD or TOD because, first of all, There is no protection over that asset during our client's lifetime. What is it not protected from? Well, it's not protected, one, from creditors, lawsuits, but it's also not protected from the nursing home. Secondarily, it is not protected during the beneficiary's lifetime once we die. So if I have it POD to my son, Danny, it's not protected during my lifetime. And when I die, if it does pass to Danny, it's not protected from divorces or lawsuits during his lifetime. Thirdly, it's possible for it to still end up going through probate. How is that? Well, if Danny dies before me and I don't have time to get back into the bank to get a new TOD, it's going to go through probate. Second, if I die and Danny is incapacitated or in a nursing home, the money is going to go to a nursing home. I see that happen a lot. There are a whole lot of people that think that a POD or TOD gives people a false sense of security. It's true, while it may avoid probate, the problem is that the asset during your lifetime and the beneficiary's lifetime are not protected. And it may not avoid even probate, depending upon what happens with the beneficiary. I recently had a POD cause a major problem because the beneficiary died and then it ended up being poured into a probate estate, and the beneficiaries were minors. And so then we had to go in, we had 4 minor children. We had to go in and set up guardianships for all the 4 minor children. And it's going to end up, this little POD or little TOD is going to end up costing this family $25,000 because things, I hate to say it, but people didn't die in the right order. So it's not what we recommend.
All right. Well, so how do we engage here? We have our Family Estate and Legacy program, which is really comprehensive planning and takes you through the 7 steps in detail, and really gets people involved in good integrated comprehensive planning. But we're doing something a little bit different these days. Our will plans traditionally cost $24.95. But during this pandemic, knowing that people need this now more than ever, we're doing our Trust Starter Kit for the same price of what a will would be under ordinary circumstances. Who knows whether circumstances will ever be ordinary again, but as long as this thing is out there, we want to make sure that we're still doing what we can for the people in our community. Now, if someone does do a starter kit and they decide to do more comprehensive planning on down the line, any fees that have already been paid to us are credited towards whatever the fixed cost of the more comprehensive plan would be. And if you want to sit down with us or talk to us about our various levels of planning through the Family Estate and Legacy program, we would be happy to do that at our follow-up conversation. So what are your next steps? When we end this webinar, you're going to be prompted to fill out an evaluation. You certainly don't have to, but we would appreciate your feedback on how we did, and maybe some things that you'd like to talk about if you want to have a conversation with us. There will be an ability through the link you see here. It is in the evaluation where you can schedule a time to have a conversation with us. And if you do schedule, you'll get another welcome email from us, and we do ask that you complete a client organizer if you have done one in the past or something like that. If you have met with us, it's always good for us to kind of reset and get that information, and we do need it a couple days ahead of time so that we can be best prepared for our meeting. So what else can you do at this point? We have written a book. We have written a book, the Estate Planning Guide. While it is available in hard copy and paperback, we do have it available for free on our website. If you go to DaytonEstatePlanningLaw.com, you can actually read our book for free. If you visit us online, you can see in that orange box there, we have a lot of estate planning resources where you can learn more about some of the things that we talked about here today. And really a lot of some other things, including advanced planning techniques and tax planning and all the good stuff that goes into really solid integrated planning. So that's kind of where you are. Ted, you got anything else for anybody? I don't see any more questions coming in.
The last thing I just want to tell everybody, look, the starter kit is a great opportunity. What I'm trying to do, Mike, is I want everybody to get on board with getting their planning done. Look, we'll do your will, your trust, your healthcare power, your living will, your HIPAA authorization, your designation. We'll get all of that in that starter kit for you. And we've reduced the price on it because we understand that people need to get this planning done. We got 70% who don't have it done. If price in the past has been an obstacle to get started down this path, Mike and I both understand that planning is a process. Remember what we said? It's a lifetime process. This is a way for us to maybe help you get started. So make sure you reach out to us, come in and see us, schedule your virtual meetings, and let's plan together and get things in order.
Well said. Everyone, thank you so much for attending this morning. We appreciate you spending a little bit of your morning with us. We look forward to hearing from you through the evaluation, and we do look forward to seeing you, whether it's in person or on the screen. We hope everyone has a good rest of the day. Stay safe out there.
Thanks, everybody.